the Society of Corporate Secretaries and Governance Professionals, and Knowledge Partner host, Corporate Board Member, along with contributor Thomson Reuters.
Hello, welcome to Governance Minutes. My name is Ken Bertsch, and I'm here today with Lydia Beebe, who's the Corporate Secretary and Chief Governance Officer at Chevron. Thanks very much for being with us, Lydia.
My pleasure, thank you.
Our topic is one of intense interest for corporate secretaries, a little bit obscure in the world at large, but what are called forum selection or exclusive forum bylaws. And we're filming this on June 26, a day after there was a decision in the Delaware Chancery Court on this very issue involving Chevron and FedEx. So we're going to ask about that a little bit later, but first I want to just ask you, what's the issue here, what's the problem, and what's the remedy?
A forum selection provision is really a bylaw that a company puts into place to require certain types of lawsuits to be brought in a certain forum or a judicial jurisdiction. And the problem is really in the last a decade probably, the number of lawsuits brought anytime you have a major corporate action has increased dramatically. I mean, it's doubled from 2005, and now some of the studies suggest that at least half of all corporate actions are subject to challenge and lawsuit in more than one jurisdiction. So this is the way I think boards have tried to address the costs of this increased risk of multiple litigation or litigation in multiple jurisdictions on the same issue.
Okay. So there have been some back and forth between companies and shareholders on this, and I know that you got a shareholder proposal at Chevron on it. So this is aside from any litigation, a different kind of appeal, and you won on that. I think I wonder if you could describe that a little bit and your experience with that.
We had that proposal a year ago, so in 2012. I might just note as a footnote that our board adopted our exclusive forum provision in 2010, and it wasn't, or we weren't aware that it was going to be controversial at that time. It was just thought to be a way to manage this potential risk. We did have this proposal in 2012 brought forward by some of our stockholders, and they had a couple issues. One issue was they felt our language was broad enough to sweep in some things that we didn't intend to into Delaware, and that it would preclude certain lawsuits from being brought because Delaware didn't have jurisdiction. And we took that argument seriously, and the board did reflect on it, and we decided to make a minor modification in our bylaws to try to address that concern. And they were pleased with that, I think, but that didn't pacify them entirely, because they felt, I think, that stockholders still had a right to select their forum if they wanted to bring a shareholder lawsuit, which is the main issue. And also, they felt that it was a right that stockholders had previously had that we had taken away, that they hadn't been allowed to vote on. And so in response to that, I think we chose to just put the proposal on our proxy rather than challenge it, because it was a way for shareholders to weigh in.
Sure.
And we did spend some time trying to talk to all our big stockholders on it and kind of explain the multiple litigation issue and how we saw it, and we were pleased with the results of that. Well over 60% of our stockholders supported the bylaw. And so we didn't have that provision, we didn't have that proposal again this year, and so in that way I think we were able to satisfy that concern of the particular stockholders submitting that proposal.
Okay. So some companies have put this out for shareholder vote in the first place. There have been some of these shareholder proposals on this. In some cases, the companies have lost votes. And one of the issues that comes up is that ISS wants to see actual damage already inflicted on the company from multiple jurisdictions. Did they bring that issue up with Chevron?
They certainly did, and both the major proxy voting advisory firms recommended stockholders vote for this, and so we were particularly pleased that our stockholders supported us in large measure despite that. You know, I think it's an interesting argument, because if you look at the financial crisis, you know, in 2007-8, the boards were roundly criticized for not assessing risk accurately ahead of time and doing enough to manage risk.
Right.
And so, I mean, this is a much smaller, I mean, the potential risk here is on a entirely minute scale compared to that, but it is just one way that boards can assess a potential risk out there, a well-known risk, well documented by a number of studies, and that they can take some positive action to try to manage that risk and to try to manage the cost of multiple litigation. So I think it's an inconsistent argument for ISS to ask for damage ahead of time when you're really dealing with a risk mitigation strategy.
Right. Okay. And aside from the changes you made in response to the shareholder proposal, there were some limits, I gather, around the Chevron exclusive forum bylaw.
Well, the exclusive forum bylaw is really tailored specifically at lawsuits that arise under the Delaware General Corporation laws.
Okay.
And so it is focused on internal affairs and lawsuits that might be, it includes shareholder and derivative lawsuits,
Okay.
which is of interest, but it's really focused only on the governance and internal affairs lawsuits, which are really, I think, the logical ones. They're going to be decided in whatever jurisdiction and whatever court they're in. They should be decided based on the laws of the state of Delaware.
Right.
So it really makes sense for them to be adjudicated in Delaware with a Delaware court.
Okay. And now the Delaware court yesterday did issue a decision favorable to Chevron and to FedEx. Can you describe what that case was about and where this is headed?
Well, we were very pleased with the results of that case, obviously. That was a decision in the Chancery Court which was based on two of the complaints of the plaintiffs in this case. And those two complaints were focused on the facial validity of a bylaw provision that would provide an exclusive forum and that was adopted by the board of directors rather than the shareholders. And so the decision really addresses those two basic issues and finds that those bylaws adopted by boards who have a provision allowing boards to adopt bylaws and that they provide an exclusive forum, that those are facially valid in Delaware. And so we think that's kind of the basis of this lawsuit, but there are some other claims in the plaintiff's complaint that were not part of this, which was really decided on motion. And so I think there's two possible avenues. I think, presumably, I think both parties, going into this approach and isolating these two particular claims, I think we presume that it would be appealed to the Delaware Supreme Court, this decision. And of course, we are very happy with it. We have no reason to appeal.
Right.
But I think it's certainly likely that the plaintiffs would. I mean, the other possible course of action is to adjudicate the other complaints that are a little bit more factually based and were not addressed, at least not addressed head on by Justice Strine's decision yesterday. Those could be litigated first before an appeal is taken. But odds are the appeal to the Supreme Court will go forward on this basic validity of these provisions, which I think would be helpful to the corporate community at large. Okay.
And how helpful is this decision in and of itself to the corporate community at large? You're obviously concerned about Chevron, but this seems to signal these bylaws are okay. There may be some other issues depending on facts and circumstances, but.
Well, and the bylaws have been very popular. The difficulty is that the bylaws are included in a lot of articles of incorporation of new companies or reincorporating companies because they're less subject to challenge. And the only people that are precluded from taking advantage of this, kind of risk mitigation strategy are the old line companies that have been established for a long time. And so it's kind of my hope that people will again feel more comfortable to adopt those bylaws and to proceed. We did have a number of companies that had adopted them, but that withdrew them once they were challenged either by a shareholder proposal or by litigation. And so I hope that diminishes and that people feel more comfortable with at least assessing whether this strategy is one that would benefit their shareholders.
Right. Okay. Yeah, I know many had been looking at this. So thanks very much, Lydia. That's illuminating.
Well, thank you. My pleasure. It's been a fun issue to work on, and we're just again very pleased with the result of the decision yesterday.
Okay. Good. Thank you.
Join us again next time for Governance Minutes, brought to you by the Society of Corporate Secretaries and Governance Professionals, and Knowledge Partner host, Corporate Board Member, along with contributor Thomson Reuters.